And this time and date set for motion for show cause for alleged failure to comply. Appearing on behalf of the moving party, the defendant in this case is attorney Amy Slingerland. This is a motion to show cause for a third party regarding allegations of failing to comply with the subpoena. Anyone here from the Dollar General or Dolgan Corp company? No response. Ms. Slingerland, you may proceed.
Judge, as you've stated, this is our motion for show cause. We've served representatives of Dollar General through our record service back in July. We've made multiple attempts to contact them. That was with a signed authorization. Then we have issued a subpoena. This was sent to the registered agent on November 8th. We did get a UPS confirmation of delivery, and I did also receive a signed return receipt mailing green card stamped December 30th. So certainly Dollar General should be aware that we're looking for these records. So we're asking for a show cause order to be issued.
Very well. Court has reviewed the motion, heard the argument of counsel. The motion is granted. Will you be presenting an order to that effect?
Judge, we did attach one as Exhibit D to our motion. However, when I looked at this morning, I realized that the date listed for the show cause is today's date, which obviously is a little soon.
Well, you want me to just modify it in writing here?
That would be perfect.
You said Exhibit B?
D as in dog.
Oh, D as in David. I'm sorry. All right. When would you be requesting the show cause date?
I would say at least 30 days.
February 14, will that work?
Valentine's Day. Sounds good.
All right. Ms. Slingerland, the court has modified your proposed order and initialed it on page 2, line 4 at the very end. Removed January 10, 2025, entered February 14, 2025 with my initials. I'll execute the order and we'll get you copies. 26, 25. We will get copies to you and by email.
Yes.
We'll send it to you via email.
Very good, Your Honor.
Anything else for the record?
No, Your Honor. It's just going to be, it'll go to Ms. Sutton, the emails on the caption.
Pardon me, can you repeat that, please?
The email is on the caption. It'll go to Ms. Sutton, not to me directly.
Okay, yes, that's where we'll send.
Perfect. Thank you, Your Honor. I appreciate it.
It is the defendant's motion for change in school district as well as transportation. The defendant is present, represented by attorney Mark Sacken. The plaintiff, Mr. Keys, appears in pro se. Will both parties please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes. Counsel might pronounce his last name correctly.
Yes, you are, Judge. Thank you.
Mr. Sacken, you may proceed.
Judge,
Stand when you address the court.
I'm sorry?
Please stand when you address the
Oh,
court.
I'm sorry, Judge. Judge, well, as an initial matter, I spoke with Mr. Keys, and we have a partial agreement as far with respect to our motion, our one motion concerning modifying the transportation time. I apologize for Mr. Keys. I thought we had a total agreement for a moment, but we were kind of doing a last second discussion, and rather than a total agreement, I believe we have a partial agreement. With respect to transportation, Judge, the exchange, the current order is that I'm paraphrasing, is that the exchange occurs of their child on Mondays, and when there's no school, mom is responsible for transportation, regardless whether it's pickup or drop off. And there's another more verbiage which provides it's the intention of the parties that the exchange will be at the school whenever possible. With respect to the exchange at the school, there's been some issues, but the parties are with respect to that have agreed that on school days, when there's an exchange, it will always be at the school. So the location of the exchange at the school at the conclusion of the school day will take precedence over any friend of the court holiday exchange times or anything such as that. So for instance, if Wednesday ends up being an exchange day, for instance, because that's the beginning of the Thanksgiving Day holiday, the exchange and school lets out early, exchange will be when school lets out early on Thanksgiving rather than when the friend of the court provides that the Thanksgiving Day holiday begins. And that would be in effect with respect to either parent, with regardless of who is exercising parenting time. So neither party, based on this modification, will gain parenting time. Neither will lose parenting time. In the grand scheme, parenting time will remain equal on a year-to-year or on a total basis.
What about if there's a snow day?
If there's a snow day, then I suppose it would revert back to what the parties would have agreed upon when there's no school. So that would, I believe, only really technically occur if it was because exchange is on it's week on week off, and exchange is on a Monday. So I suppose in that circumstance, exchange would continue to be 6 o'clock on that Monday because there's no school. So the parties would not be exchanging at the school.
So that's your understanding regarding that portion of the motion.
Yes, that portion only.
All right. Mr. Keys, did you hear all that, sir?
Yes, I
And
will agree with that.
that's your understanding as well?
Yes,
No one has forced you or threatened you into this arrangement?
No.
And you believe it's in the best interest of the minor child?
yes, it's fair.
Very well. So you can present an order to that effect.
Okay, thank you, Judge.
Regarding the second part, is this something you both need to discuss yet? Or is this something that there's no agreement and you wish to?
The parties wish to proceed. We attempted to resolve that issue, but unfortunately, we have not been able to.
That's what the court's for. Go ahead.
And should I, with respect to, I guess, transportation, I'll address that first. The order currently, like I stated, provides that mom is responsible for transporting the child. This has caused a burdensome issue. At the time, in I believe 2019 or 2020, when the judgment of divorce was granted, the parties agreed on this, at least from Ms. Welchner's perspective, because there was some inconsistency with dad providing a child when it was his responsibility pursuant to what the Huron County guidelines provide. So she said, you know what, I'll just make it easy. It's been difficult to wait around if there's confusion or if he shows up late. I'll just pick up the child when it's his parenting time and when it's my parenting time. She has since moved. She since has another younger child. Picking up the child during both his and her parenting time has become burdensome on her and frankly not great for their 9-year-old either. So she's simply asking that the court adopt what I understand the Huron County Friend of the Court policy would be, which is that, and this only would be with respect to non-school days. So it really isn't too many days over the long course of a year. So she's asking, just like the guidelines would provide, when it's her parenting time and there's not school, Ms. Welchner would pick up the child from Mr. Key's house. However, when it's Mr. Key's parenting time on Mondays and there's no school, then Mr. Keys would be responsible for picking up the child at her house. We believe that's only fair. I understand it's a change of what the current order provides, but I do believe Ms. Welchner moving to Fillion, having now a 2-year-old child who she's responsible for, I believe that's warrants along with their child now being 9 years old, warrants a change of circumstances which would warrant that policy, which again would be consistent with what the Huron County Friend of the Court, I understand, provides.
So that you're alleging that to be the change in circumstance
Yes, Judge.
or proper cause, for instance.
Yes, Judge.
Well, how do you respond to the argument that, hey, look, your client voluntarily moved?
I understand that she voluntarily moved. She moved to a place that's closer to where she worked. It's a place that her 4 other children or 3 other children attend that school, and her 2-year-old goes to preschool or pre-care there as well. She moved, but she moved with not for a reason to obstruct any parenting time, not to cause any problems for anybody. And even though she moved for a valid, legitimate reason. So for that reason, I believe that still would be a change of circumstances. And in addition, her having a 2-year-old child also would be a change of circumstances. And clearly it was her choice to have this child, but regardless, she's not asking, at least in the motion, for any draconian change just for when it's dad's parenting time, he should pick up the child. When it's hers, she should pick up the child. And again, she's not asking for any change during the school year. During the school year, so long as there is school on that Monday, she's still saying she's going to drive to wherever this court determines the appropriate school should be. It's just on the relatively limited times, except I guess during the summer, which would be more common, of course. So a number of times throughout the year where this would be relevant, Judge.
All right. Let's talk about the schools.
Yep.
Now I'm going to get a response here.
Yes, Judge.
Go ahead.
Okay, Judge, there are, I'm sure the court, of course, has reviewed the motion. Judge, the parties, they have a 9-year-old daughter, Ren. They were divorced in 2020. Ren was.
Don't use a child, but I understand.
Understand, Judge. I apologize. I don't practice in this court quite often. Okay, they have a 9-year-old daughter. Won't use her name. She was approximately 4, almost 5 at the time of the judgment of divorce. I've cited cases in my brief where there were even longer distances between the parties where they moved rather than, or my motion, I should say, than this, where the court provided that that does not modify the established custodial environment. So therefore, the appropriate standard would be, so long as proper cause or change of circumstances have been established, the proper standard would be preponderance of the evidence rather than clear and convincing evidence that the change would be in the child's best interest, Judge. At the time of the judgment of divorce, my client, she lived in Owendale, so that she agreed for schools to be in Owendale. Again, the child was only 4 years old, almost 5, so the child was not even going to school at that particular time. Mom has always worked as an assistant teacher in the North Huron School District. Recently, in August of 2024, her and her 5 children, her child in this case, her 3 older children, and now her 2-year-old, all moved to a house in Fillion in the North Huron School District. They bought the house. She paid for the house in cash, so it's not even a mortgage on the house. She bought the house entirely. So this is not a situation where she's renting a place and things could change from year to year. She bought this house outright. There's not a mortgage. She will be living in this house permanently. I submitted as part of exhibits to the motion. If the court would like, I could establish a basis for it, where the statistics academically from the U.S. News and World Report, a very reputable organization, provides that, frankly, the North Huron School District academics are superior to the Owendale academics. With respect to math, my exhibits demonstrate that Owendale schools for elementary is the bottom 10 is at the 10% level, where middle school is at the 5% level, and by percent in this case, I'm discussing the bottom 10 and 5%. North Huron is 27% for elementary, 27% for middle. With respect to reading, Owendale schools are at the bottom 10% for elementary, 35% for middle school. North Huron is superior in both. Elementary, it's 42%. And for the middle school, it's 42%. There are more extracurricular opportunities for extracurricular activities in the North Huron schools. I also attach those as exhibits to my motion. Owendale, my client, would testify that they've been cutting their extracurricular activities extensively over the last number of years, whereas North Huron schools, the extracurricular activity opportunities are robust, not just for athletics, but for robotics, academic extracurricular activities, things of that nature. Their daughter, which is wonderful, regardless of how this court decides today, I understand is getting excellent grades. So this is not one of these cases where we're saying she's doing terribly in Owendale, Judge, so there needs to be a change of circumstance, a change so she goes to a better school so things improve. She's doing great, which is wonderful. But my client, they very much believe that she's not being challenged at the Owendale school. This school in North Huron, she believes, is more academically challenging, more academically rigorous, which is a good thing. And a change would be helpful to her, so she's not bored at school. So she continues to thrive, and she continues to get challenged. I was informed that Mr. Keys actually has an older child, and when she was around 9 years old, Mr. Keys made the decision to change the 9-year-old's school from that school to a different school, not the North Huron school, but a different school. I understand also because it was his belief at the time that his daughter was not being challenged in the Owendale School District. Of course, he'll have the opportunity to discuss that himself if he has a different perspective. My client also has experience and observed that there has been a greater amount of violence from her perspective at the Owendale schools. Recently, there was an incident with a child bringing a knife to the school. She's experienced that many of her children, their daughter's friends, or parents, I should say, have removed those children from the Owendale schools based on concerns over lack of protection of the children. Just yesterday, she told me that her child was bit at school, and that just kind of fits the pattern. There's been school board meetings, which she's heard about or maybe even attended, where this issue of violence has been raised by other parents as a concern, and she does not believe that there's been really much to address that. Again, she's the teacher, an assistant teacher at the North Huron School, so she would have very personal knowledge as to what violence or lack thereof or protection, safety measures are in place in the school district where she works. And she reports that there's really no issue whatsoever as far as violence, and there is excellent protective measures in place. As I stated, she works as an assistant teacher at the North Huron School District, which, with a daughter now at 9 years old, I think is in and of itself a benefit. If the child's sick, if the child is having an issue, so she can monitor how things are going with the child. A mom working at the school where the child goes to school would be beneficial. She has 3 other children who go to that school. She also has a 2-year-old who goes to pre-care at that school. So as far as the community that their daughter would have by changing schools, that also would have an extreme benefit to the school, to their daughter to go to the same school where 3 to 4 of her siblings already go. I don't believe she has any siblings or any relatives that go to the school district where she's enrolled in right now. My client, Miss Welchner, also takes their child after school to religious activities. For instance, their daughter likes to go to God's Club after school. I believe it's on a weekly basis. And based on the distance, unfortunately, when their daughter is with Mr. Welchner, it's just not possible for their daughter to attend God's Club. But when she's with my client, she's able to attend God's Club. I'm not aware, or my client isn't aware, that Mr. Keys does do religious activities with their child, which would be obstructed by a change of school district. As far as the involvement of the parents, I don't think there's any question that Miss Welchner is the more involved parent with many of the academic and important issues concerning their daughter. I'm told she's the only parent who takes their daughter to medical appointments, or at least I should say annual well child care scheduled in advance medical appointments where she gets her vaccines and checked and for things like that. She's the only parent, I'm told, who schedules dentist appointments and takes the child to dentist appointments. As far as parent-teacher conference meetings, I'm told that my client is the only parent who goes to parent-teacher conferences in person. Perhaps Mr. Keys will speak to the teacher over the phone on certain parent-teacher conferences, but I believe that being there in person demonstrates that she's a more involved parent with respect to that. She's also in constant communication with their daughter's teacher. I believe that Dad will probably argue that this would be difficult for him as far as the distance is concerned. I'm told that Dad during parenting time works from home, or at least that's what their daughter reports. So I understand. He could testify to himself, but I understand that he works from home during those parenting time sessions, so he can be there during pick up and drop off, and he can do pick up and drop off himself. I'll let him speak for himself. I understand that often he actually works in Bad Axe, which is close to where the school district would be. And as far as drop off, my client has done the research, and I'm told during the Huron transportation department, she can drop their child off to that department after school. She would bring the child to the school, and that child could take the bus to dad's house. So dad wouldn't even have to, at the end of the school day, be responsible for picking up the child. His responsibility, of course, still would be the beginning of the school day, which we acknowledge would be a commute for him. But this is a commute that my client has been doing. I understand it's about 32 miles from dad's house to the school, which I'll acknowledge is not a short commute. However, school starts early in the morning, and there's nothing that would prohibit dad from being able to drop the child off in the morning, come back and be able to start the school day, his work day, when the work day would begin, Judge. So for those reasons, we'd ask that the court consider changing the school district of the minor child.
Mr. Sacken, what about it's fair to say, based upon your motion, the child has been at the Ongage School District from at least pre-K all the way through to her current level, correct?
That is correct.
I'm assuming she's made friends.
She has made friends, yes.
I didn't hear anything regarding that.
Okay.
I mean, obviously, if you're potentially plucking a child out of a school district that's the only school district she knows, and removing the child, how does that square?
I appreciate the question, Judge, and I guess the 2 points. One is that she already does have a deep connection with the North Huron School District because she attends extracurricular activities with her siblings. She's there quite often, and what I would say, me discussing, I suppose, what her preference would be, as the court, I'm sure, would point out, would be hearsay. However, the court rule does provide that it would be appropriate for this court, I think, at an age of 9 as well, to perhaps hold off on rendering a decision and meet with the child in camera and ask her what her preferences would be. My client strongly believes that if asked, that the daughter would say, I would prefer going to the North Huron School District. Of course, I can't tell you what she's actually said, but my client believes that. So I would strongly encourage this court to, if the concern is pulling her away from her friends, making her feel uncomfortable, this is something she doesn't want to do. My suggestion would be this court ask her herself, what would you prefer and why, and take that into consideration.
You're welcome. Thank you. Mr. Keith, your response, sir.
I talked to Ren too about maybe moving schools, and she prefers to stay with her friends. Guys Club, we do have one in Sebring, and most of the time it's when she has her.
Sir,
Okay. I'm sorry. With her school, I have everything here that she's doing great. Now transporting, I talked to, I have a letter here from the transit. Yeah, there is no pickup or drop off in Sebring. I would have to take her here every day. Okay, I work 1 day a week here in Bad Axe as a maintenance technician. My other job is in Cass City and Sebring. My daughter will be basically Monday through Friday when I have her 20 hours in a moving vehicle. And now the response to her getting bit yesterday, they both were horse playing. I checked my daughter, no redness, no nothing at all. She's doing great. And the moving of schools, I live in Sebring, where if we are concerned about that, there's USA School, which her family all lives there. Her dad, stepmom, mom, grandma, aunts, uncles. She has family that even works at that school, Your Honor. But I'm not.
There's also Bad Axe School, which is right in the middle.
That is correct. But again, Ren's happy, or my daughter's happy there. Yesterday, she went to basketball practice there. Their school is getting better. Not only did some kids leave there during that little situation that happened, I have letters from the school that says that they took care of it. Everything is totally fine. And she did want to join basketball, and she's doing good. The school does have, like, they're volleyball champs. They have a good girls basketball this year. They're doing good. Other than that, I will agree on transporting, but changing schools, I just feel as of right now, my daughter should stay where she's at. She chose to move on her own, not us.
Okay. But you're okay with the transportation aspect?
Yes, I will agree on that 100%.
How do you feel about the court speaking with your child?
That's totally fine. Absolutely.
Okay.
Yes.
The youngest age, Ms. Schultz, how old was the youngest child you spoke
The State Court Administrative Office has advised children over the age of 7 must be interviewed. Under the age of 7, it's court's discretion on whether or not they're at a sufficient development.
But what would be the youngest age that we've had interviews?
You and I together, I believe, was 7. Me personally, I have had a 6-year-old.
Okay. And we have a 9-year-old, which sounds like, according to the grades that both parents are reporting to, that the child is doing exceedingly well, and that's wonderful. What the court will do, first, court will grant the motion regarding the transportation. Stipulated to Mr. Keys has no objection to the transportation aspect. That's the second motion. Regarding the school district, court finds that there is a change in circumstance. It's based upon a preponderance of the evidence standard. And the change in circumstance here is the fact that we have additional children involved on mother's side. That's not the end all here. I mean, the court has to take a look at this. The court will consider the statements made by counsel and Mr. Keys. The court wishes to speak to the child, and I'd like to do it sooner than later because the end of the semester is coming. And if there is any potential change here, I do not want to have the child moved, if the child is moved, when we're in the middle of a semester or marking period. I don't think that's appropriate. Your client raised her hand.
Yes, Judge. She's about
When does the semester change? Am I wrong about that?
Yes, Judge. She informed me that the semester has actually concluded.
It just concluded.
May she speak, or would you?
Yeah, she may.
Okay.
North Huron has concluded, but Own Gage has not. So
Okay.
she would be finishing still at Own Gage, but North Huron has begun second semester.
Okay, so I'm half right.
Yes.
Round up, 400.
The court has to consider a number of factors, and the court will, after speaking with the child, issue a written opinion relative to this. When can we schedule the child? Who's with the child right now?
I am.
Through Monday?
Yes.
Tuesday.
How about Tuesday?
Tuesday would be fine.
Now,
Yes.
here's just a word of advice, to both parents. Please, I'm not saying you would, but please don't inundate your child with, you got to tell the judge this,
Nope.
you got to tell the judge that. None of that. We're able to see through that. And we just want the opportunity to speak with the child relative to that issue only. Any questions, sir?
Judge, just for clarity, the court stated that we have an agreement with respect to transportation.
That's what I just heard him say regarding the other aspect, regarding he picks up on his time, she picks up on her time.
Mhm.
Oh, you do agree with
State
that?
that.
Yes,
And it would be at each other's respective residences?
that's fine.
Oh, okay. I wasn't clear on that. Okay, great.
And if the parties mutually agree on another location, if there's a midway point, feel free.
Absolutely.
But we have a fallback provision in the event that parties do not agree. So along that lines, Mr. Sacken, please prepare an order regarding the 2 issues of transportation. And we will meet with the child Tuesday, but we'll then issue opinion after that. Do you have any questions, sir?
Your Honor, if she's going to be talked to on Tuesday, can I be here as well?
You can be here, but no one's going to be in the room other than
Okay.
the court and myself.
Okay, that's fine. And again, Your Honor, I hope the court takes in consideration that on my week that I have her, she's going to have to get up at 4 o'clock in the morning. She's going to be 20 hours in a moving vehicle, which is not right for a 9-year-old. I'm sorry, that's just too much.
Understand, the court will weigh
And
up
if
that.
the party wants to sit here and put her in a better school, I'll agree with you here in Bad Axe is fine. It's 50-50. Or even Lakers school is fine. It will still, she will not be in a moving vehicle that much. That's just wrong.
Well, I just heard Mr. Keys say that he would even be in agreement with Bad Axe or Lakers.
I still feel that where her brothers attend, as well as the community that we live in, I work in, is going to be the best environment for her. It's a school district that I'm very familiar with, and she is also comfortable with. She expresses that she wants to
Well, I don't
attend
want
with
to, I
us.
don't want to.
Oh, yeah, I'm sorry. And so I feel
Let me
that.
ask you this then.
Mhm.
You've been working at the school district for a number of years, correct?
Yes,
You never made that argument initially.
that's correct.
Now
So
you're making it. See what I'm saying? It could be an all or nothing here.
I'd be glad to explain my reasoning behind that. At the time of our divorce and us being established in our home and their school, did not want to make drastic changes for my children. They were comfortable where they were at. I made sacrifices with my job, being late every day so that I could get them to school and make sure that they were happy where they were at. I waited until my children were ready to make a big change. We were all ready to look for a larger home. I spent a significant amount of time looking for a home that's adequate for us in size as well as price and location. We all loved our home. We made that move. I then asked my children, are you ready? You know, if we make this move, are you ready to move schools? This was the time that they were all ready for that change.
But you filed this motion last time, not too long ago.
I did file it in February, which was as I was in the process of purchasing the home, hoping that I could either back out on the home if this was not going to happen for my family, or, you know, make the decision based upon that. We weren't able to obviously discuss it because there hadn't been a change yet. So I did come back with what I thought were your words of, you know, at this time, we cannot entertain this motion because there has not been a change in circumstance. I went ahead and did it. I explained to Ren that at this time, she will just stay where she's at. I will continue to make sacrifices, getting up early, packing up my other children, driving her to Engage, all of us going to North Huron as a family. And that's why we chose to do this.
Did you have anything else?
Well, Your Honor, yeah, when last February you denied that and she went ahead and she moved anyways. With my company, I work for KMG. They offered me better pay. We have properties all over Michigan and all over the United States. And they offered me Frankenmuth, Bay City, more money. I could have went and got a house, but I had to deny that because of my daughters. I had to turn all that down. I didn't get to move. So right now I'm still in Seagoing, which I'm happy because my daughters are happy.
Mr. Sackett had made mention that you have another child
Yes,
and you switched school districts. You tell me
when
about
we went through the divorce, my daughter did not want to be around any of it. She was going through a lot and she asked if she could move. And I said, sure.
From what school district?
Owendale,
To where?
USA school.
USA. Okay,
Yep.
very good.
And she has since moved again.
She moved now. She goes to Lakers because of an incident that happened outside of USA school. And she did not want to see those boys ever again.
Okay.
It was bad.
I've heard enough on that issue.
Okay. Thank you.
All right, we'll meet with the child on Tuesday. We'll go from there.
What time would that be?
Here are the orders of the other child.
Hello, Judge. I'll provide them on the 7th day.
After school. I know I put three.
That'll be all. Thank you, everyone. Would you please state your name for the record?
My name is Kayla Nicole Ginther.
And you're the plaintiff in this matter, correct? Have you lived in the county of Huron at least 10 days in the state of Michigan, at least 180 days immediately preceding your filing this complaint for divorce?
Yes.
At the time you filed this complaint for divorce, was Mr. Samuel also a resident of Huron County, Michigan?
Yep.
Is it true that you were married on March 28th of 2014 in New Baltimore, Michigan by a person authorized to perform marriages in the state?
Yes, it is.
And you stopped living together as husband and wife according to your complaint on or about December 20, 2016. Is that correct?
Yes.
And your name has always been Kayla Ginther,
Yep. I never changed it.
and your husband's name has always been Jesse Samuel.
Yes, as far as I know.
All right, there are no minor children in this marriage, correct?
No.
I have to ask you, are you currently expecting?
No, I'm not.
You've alleged in your complaint for divorce that there's been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed, and there remains no reasonable likelihood the marriage can be preserved. Was that true at the time you filed the complaint?
Yes,
It's still true today?
absolutely.
Briefly, in your own words, can you explain to the court why you feel the marriage cannot be preserved?
He left me when our last day we lived together and moved into another woman's home.
All right, is there any
And-
chance of reconciliation?
No,
The court
never.
did not grant you an absolute judgment of divorce. Would you be willing to resume a husband-wife relationship with Mr. Samuel?
never. No.
According to your proposed judgment, which you have presented, well, let me ask you this. Are you requesting, either party requesting spousal support?
No, I just would request that he pay half of what I have on my receipts here that I had to pay to get the divorce going and for the proceedings.
Well, let's go over the marital issues first. Is it true that neither party would be awarded spousal support and that issue would be forever barred?
Yes.
In other words, you're not going to receive spousal support. He's not going to receive
Right.
spousal support. Okay. Do either of you have any pension, annuity, or retirement accounts?
I left my job I was at for 6 years and I It was like 2,000 and it's already gone. I was off work for a couple months in between jobs.
So you don't have one?
Not currently, no.
Does he have? If he does have one, what's your position regarding that pension annuity? Or
I do not want anything from him besides what's on what I had to pay to get divorced, basically.
okay,
That's
so
all I asked for help with.
each party would, if they have any pension annuity or retirement account, would be able to hold that free and clear from any claim to the other party.
Right.
If there is one.
Yep, yep.
And the same if there's any life insurance carrying cash value. I'm not talking a term policy where you pay money and they pay you a certain amount upon your death. I'm talking about an investment account. You don't have anything like that either. do you?
No.
What about, I'm assuming you acquired personal property during this marriage.
I have a one vehicle and that's it.
What type of vehicle is it?
An HHR
What year?
2007.
Does he have a vehicle?
I do not know.
If he did, would he hold his vehicle and you hold your vehicle free and clear from any claim to the other?
Yes, absolutely.
Any debt owing on any of these, on this vehicle?
Nope.
Any mutual credit card debt?
Nope.
Any student debt?
Nope.
Do you own any land or real property?
No, I do not.
Does he?
I have no idea.
Nothing acquired like that during the marriage.
Not that I'm aware of.
Household contents, have those already been divided?
Yeah.
So there's nothing he's holding that you're wanting, and there's nothing you're holding that he's wanting.
Not that I'm aware of.
Okay. Are there any other marital assets or debts that he's not addressed on this record?
No.
Okay. Thank you. All right, Mr. Samuel, are you requesting spousal support?
No, Your Honor.
Any pension, annuity, or retirement accounts that you have?
No.
Any life insurance that carries cash value? No. Any land, homes?
No, Your Honor.
Is there any personal property that she has of yours or you have of hers?
No, Your Honor.
Everything's already been divided?
Yes, sir.
Okay. Any other marital assets or debts that we've not addressed?
No, Your Honor.
Okay, I'm going to go back to Ms. Ginther. What are you requesting?
I had to pay to get him served the papers and pay to file for the divorce. And I was just hoping at least half would be fair for him to pay what I had to pay half of.
How much did you pay in total?
The service fee was $72 and the fee to file was $175. And I have both my receipts with me.
What's your position on that, sir?
I agree with that.
Okay. Appreciate that. Make me get out the calculator and figure out what happens. $123.50.
That's fair.
Is that something you can pay to her within the next 30 days?
Yes, Your Honor.
All right. Based upon the testimony presented, the court finds that the statutory grounds for divorce have been established. Therefore, an absolute judgment of divorce is granted to plaintiff Kayla Ginther from the defendant Jesse Samuel. I make a finding there are no minor children of the parties. Neither parties awarded spousal support. The divorce judgment shall include the property division that was outlined on the record, as well as any and all provisions concerning pensions, annuities, retirement accounts, etc. And in addition, father shall pay to the mother, or father to mother, I'm sorry, husband shall pay to spouse, that is, the amount of $123.50 within 30 days. As long as you provide it in check, money order, cash, whatever, however you arrange that, as long as that's done within 30 days, that'll take care of the matter. The court has a proposed judgment here, and I will also place on the record, each party is awarded the personal property currently in their possession, be fully responsible to pay any debt related to that property. There are no debts to be divided. Do you own a vehicle, sir?
Yes, Your Honor.
Okay, what type of vehicle do you own?
It's a 2002 Malibu.
Okay. Each party will keep their respective vehicle currently in their name and possession, and the other party has no claim to it. Now, neither vehicle has both names on them.
Correct.
Great. Parties do not own real property. I already addressed the pensions and life insurance issues. Cost and fees shall be split. Okay. Thank you. 123. 30 days of this judgment. And January 10th. Right. The court's prepared the judgment. What will happen next, folks, is that this judgment and the file will be taken to the county clerk's office. You'll be able to get copies of those judgments today. And I wish you both the best.
Thank you so
Good luck
much.
to both of you.
Thank you.
This is the petitioner's motion alleging a violation of personal protection order upon the defendant. Plaintiff is present. She is in the courtroom. The defendant is not present. The court has inquired of the court staff relative to checking in via Zoom. And in by that name. Actually, there's no one checked in right now. Court calls Esteban Inza. No response. Defendant is not present. Referring to the court file. A motion to show cause had been filed. It's alleging November 20th that the respondent has been harassing the petitioner through email that won't stop, accusing him of things that are not true. Very hurtful. Stress from this is debilitating. Can't function in day-to-day life. There were attachments that were provided to the court. Clearly, and dated as late as December 13, 2024. The court's personal protection order was entered in this case on November 20, 2024. Miss, was there service here of this personal protection order?
Yes.
Court looked at the response as well from Mr. Inza. Clearly, Mr. Inza is aware of the personal protection order, and he is not present. As a result, for the respondent's inability to appear, I want to make sure on December 20th, 2024, Mr. Inza sent an email to the county clerk's office regarding whatever summon I'm getting from Reagan Elizabeth Rysdale from your office. I've never followed this woman. In fact, I had to ask her to leave my property multiple times. So clearly it indicates to the court that he was served with this as well.
Can I say something real quick?
Not yet. But he was served with the show cause as well. There's proof of service. The court is issuing a bench warrant for his arrest. What would you like to say?
Oh, going to his place, that was a mutual agreement going back and forth, and because he was taking care of my cat. He never asked me to leave. He's never asked me to leave in the 5 years we had a relationship.
Well, if you have a personal protection, I'm not going to tell you what
Yeah.
to do, but there's a personal protection order.
I want him to stop, and I don't think he will.
Well, bench warrant will be issued for his arrest. $3,500 cash surety. He's at the post of bond. Otherwise, bench warrant for his arrest. You're all set. Thank you. 12 DM. This is time and date set for motion hearing. Parties are present. Would you both please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. The court is in receipt of a complaint that's been filed through the front of the court's office regarding the minor child, which we won't mention the child's name. And the court read that. That was dated December 10, 2024. Is there anything from the front of the court regarding this? Mr. Holdway.
Yeah, just that we were last before the court on December 6th for a parenting time violation, was second subsequent. Court had found Ms. Murray in contempt court at that hearing. The front of the court had received, as indicated, a complaint from Mr. Yarbrough dated December 11th that he learned that the minor child had been hospitalized sometime around that last court date. That he had no information on it. He had found out the child was transferred to another facility, and when trying to obtain information from a third party due to the current no contact between the parties, that he was not able to get any information. He found out where the child was hospitalized, contacted the hospital. They could not give him any information because he was not listed on any of the emergency contact, obtained the PIN to get any type of information regarding the minor child and reasoning for hospitalization. So with that complaint and the parties have joint legal custody, the issue of alleged legal custody violation was set before the court today.
Thank you. Mr. Yarborough, is there anything you want to supplement regarding your motion?
Just that basically what I said in my complaint, that I was not informed ahead of time that he was in the hospital until after that court date that was at that time. And then I tried all weekend long to find out everything I could possibly. And then it took, I think, the last 2 days he was in the hospital when I found out some of the information, and I didn't get the full story of what happened.
And you have joint legal custody according to Mr. Holwick, and you understand that, correct?
Correct, yes.
Court does take judicial notice of its prior orders, but I read in here that there is some sort of bond condition that you're not to have direct or indirect contact with Ms. Murray. Is that still in effect?
It is.
It was in effect at the time?
Yes.
And when you tried to obtain this information regarding the minor child, I'm assuming you didn't contact her directly.
No, I'm ordered on the other court that use her mother as the third party to contact her about our child. So I did that, and I asked her where our son was and what hospital and why he was in the hospital, and I never got no response at all. I called her, didn't answer. I texted her, no answer. I didn't get a response until I think it was the second to last day when he was in the last hospital, wanting to find out where he was at and what was going on.
Anything else before I go to Ms. Murray?
Not at the moment I can think of, no.
That was the same weekend that you ordered me to go to jail. He did find out from Terry, the CPS worker. I was told that from her.
Well, that's hearsay, but go ahead.
And he told her that he would come up to the hospital, which he never did Friday night.
Well, I don't care about coming to the hospital. I want to know if the child was the child hospitalized?
The child was hospitalized.
And so what did you do as part of joint legal custody to let father know what's going on?
There was nothing that I could do besides have my mom contact him, which I have text messages, screenshots, and she's called him and he's never answered until my other kids and dad got involved.
So when did you send texts to your mother to let Mr. Yarborough know what was going on?
Last time I knew, she texted him that Friday. And the minor child was at that hospital before.
Okay, so when the child was the child hospitalized in another location, I'm assuming?
It was here and then he got sent down to Harbor Oaks.
Okay. And when the child was transported to another location, did you provide the hospital with the contact information for father and PIN and all that stuff?
They've had all that information.
No, I didn't ask you.
There was no
Listen to my question, please.
I never got a PIN from that hospital.
You never, on the day that the child was hospitalized, listen to my question, please. When the child was hospitalized, did you inform father of what was going on?
I was in court over Zoom when I was in the hospital with the minor child that Friday morning.
Okay. So after the hearing, did you make arrangements that father knew what was going on?
I had to make other arrangements and I was trying to do that all afternoon.
Okay, so the answer is no, you didn't.
No. And he told other people that he was coming up there to relieve.
Listen to my question. Did you make arrangements to make sure father knew what was going on regarding the child?
No.
Why not?
I had to make other arrangements for my other two for me to go sit that weekend.
Okay, let's put the shoe on the other foot for a moment. Assume this is dad doing this and you're left in the cold.
He has done it.
No. You're not. Please listen to my question. Assume the shoe is on the other foot. He has the child's hospitalized, and you know nothing. How would you feel about that?
I would have every legal right to call up there to get information, regardless if there was a pin or not.
I'm not asking what rights you have. I asked would you feel?
I'd be a little bit upset, but I would try in my power to get all that information, regardless of
According to the
what.
information I've just heard a moment ago, he attempted to call the hospital and they won't give him any information because he doesn't have a pen.
I was given no pin,
I'm not asking about what you were given.
but I was not given a pin to give to anybody else.
I find you in contempt. This is the second time. And it continues. It's gamesmanship. It's playing on your behalf, on behalf of a minor child that needs both parents in the child's life. And I find you in contempt of court for failing to comply with the legal custody requirements. We have a child with special needs relative to his medical condition. And all I know is whether I'm not the custodial parent or if I am the custodial parent and I care 1 ounce for that child, which as a father, I would care much more than an ounce, I would be worried to death thinking what's going on. And all it takes is contact. All it takes is just a simple text to your mom. Let him know what's going on. But that wasn't done.
But he doesn't answer his phone. So how
I'm not listening to the excuses anymore.
if she called him on voicemails, how?
It would be a lot better if I had information to indicate that at least someone reached out to him. No one did, according to him. And you said you were focusing on your other 2 children.
Because their prior arrangements, because you ordered me to go to jail that weekend.
Right, for failing to comply with court orders yet again. What time did you have to report to the jail, by the way?
12:30, and there was no female COs on that weekend.
Your Honor.
Yes.
Can I say to the court on that report time at 12:30, listening testimony, I do believe if my memory serves, last testimony was had to report at 12:30 because she was working until midnight and had to make arrangements for the kids. But from testimony today, I would believe that she wasn't working that day to report to jail at 12:30. She would have been with the child, not at work.
Oh, is that true?
Correct, because he was supposed to come up to the hospital and relieve me to go to work, and he never did.
How would he be able to go to the hospital if he didn't know?
He already found out earlier
By
that he
whom?
was there.
By who?
From Terry. That's exactly what I was told last week.
So you need, if a parent needs to know from Child Protective Services that an individual your child is being treated, that's not proper. You shall serve 2 days in the county jail. What time do you finish work today?
I'm supposed to be at work right now, and then to take today off.
So you're off today?
Yep.
You work Saturday?
No,
You report to the jail at noon today. You'll serve today and tomorrow and be released Sunday morning.
is there a female CEO on?
You'll have
That's
to
all I'm asking.
You're going to have to contact the sheriff department.
Before 3 o'clock today, Your Honor, yes, there's a female CO on duty as I go to the jail this morning on other matters.
I don't like doing this, but it's getting more and more blatant, and this is for the child. That'll be all.
Your Honor.
38DS. This is a show cause, Dunwoody, regarding allegedly speaking with the child regarding adult topics. Mr. Olson objects to a friend of the court recommendation. Will both parties please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Thank you. Anything for the front of the court? Ms. Schultz.
Your Honor, as it relates to the parenting time show cause, on November 26th of 2024, an order regarding custody and parenting time was entered. That order provided that communication between the parties is limited to issues involving the child. Neither party shall discuss adult topics with or in the presence of the child. and that the court had previously prepared a child support recommendation. The court had adopted it in the amount of $390 per month, but also referred the issue of support back to the friend of the court to look at the issue of overtime earnings. We did prepare an updated recommendation, and that is Mr. Olson's objection today. The updated recommendation would have set support in the amount of $379 per month. However, that did not meet the threshold for modification under the 2021 Michigan Child Support Formula, and the friend of the court has recommended support remain set in the amount of $390. That calculation was based on a 40-hour work week without overtime earnings. I did have an opportunity to speak to Mr. Olson by phone after he filed his objection. And he had advised me that he had enrolled the minor child in his employer-sponsored healthcare coverage plan.
Great.
So I did prepare an additional calculation on December 11th. That was not sent to the parties, but it's in the front of the court records. And based on the addition of the healthcare, the support calculation was $352 per month, including $20 ordinary medical. It still would not meet the threshold for modification. However, I believe there should be credit for the health.
Okay, thank you. All right, let's address the support issue. Mr. Olson, you heard all that?
Yes, Your Honor.
What's your position regarding all of this?
It's based on the previous year's work, and there's been a lot of cut and work hours. I've give ample proof and evidence of hours I've been working, and being sent home with a $300 paycheck does not make ends meet. So basically, I'm going to wind up losing my place over overpayment on child support.
Well, according to the friend of the court, they're not doing a calculation based upon overtime. It's based upon 40 hours.
If I was getting 40 hours.
So are you claiming you're not getting 40 hours a week?
I've sent in the proof for that.
No, I'm asking you.
No, I'm not, Your Honor.
So how many hours are you working per week?
I've been averaging roughly 32 hours the last 2-3 months.
And is that going to change? Is any understanding what's going to happen with that?
From what I understand, to be honest, they got new clients, so we may be getting more work. So I may be getting more hours.
Ms. Schultz, when you did your last calculation, what did you consider? Did you go back to the guidelines, or did you use current?
We were provided with updated pay records on December 9th. Those pay records indicated there were 40 hours being worked at that time, and we based it on 40 hours. Mr. Olson doesn't have a standard hourly wage based on the nature of what his work. It depends on, it's tied in part to incentives based on their production for the company that he works on. So there's a varying rate of pay per day, but we did look at the 40-hour week.
So according to the stubs and information provided, when was the last time he was working the 40 hours?
These are dated September.
And he turned these in, correct?
Yes, September 9th through November 24th. November 17th was a full 40 hours. The following pay included the holiday, so that didn't reflect the full 40 hours.
Okay. How do you respond to that, sir? It sounds like the information you provided indicates 40 hours a week.
My pay stubs show less hours than that. There's hours, may have 1 day or 2 days of the week where it's 40 hours, but there are 2 or 3 days where I'm missing work or not working.
But all your pay stubs on balance show 40.
Yes, but not all of them.
Well, according to the information provided to the friend of the court recently,
It'll have to be
other than the Thanksgiving holiday. Anything else, sir?
there. I had to send in the proof, so I mean, if it's there, then it's there. I've looked over it and I know what I see.
Okay. All right. Let's talk about the show cause. I'll make my ruling here regarding all issues after I hear this. You're alleging that the child is saying things that are not appropriate. What's going on here?
He is being told that he needs to have a break from coming to see me, or he doesn't have to come see me. And I asked him why, and
Okay, well, that's hearsay, but I think I read in here that you may even have video to this.
yes, Your Honor,
What's the video going to show?
it's gonna show him tell me why he said it.
That's, in your opinion, obviously a violation of the rules.
Yes, sir.
Okay. Ms. Dunwoody, how do you respond to this?
Well, I know what he's saying because Brady says the same, similar things to me. I mean, he says other things too as well. But with that being said, our son's 8 years old. The whole parenting time with his father, this is all new. It's out of his norm. I think with spending more time with his father, he will adjust to it. But some of the things I disregard, some things I don't. Because the things that he says to his dad, he does say to me as well. And as far as
Do you have any opinion as to where that's coming from?
he is currently being doctored through his doctor, through HBH, and a doctor in Saginaw for autism. And I would never say anything to Brady about the situation or to his father or about his father to him until minutes before his visits so that it doesn't lead to any conversation whatsoever. So when I asked him if he wants to go, it's time to, he says, I don't want to go. I don't want to go up there. I said, Brady, you have, or sorry, my son says, you have to spend time with your father. And then he goes.
What do you do to encourage a positive relationship between the child and dad?
When he says he doesn't want to go, I said, Brady, you have to spend time with your dad, just like you spend time with mom. I mean, I don't know what else to tell him. I mean, that he has
Do you
to
want
spend.
him to spend time with dad?
I do. I believe,
Maybe that's a possible change. Instead of you have to do this,
right,
is son, I want you to do this.
right,
Do you engage in that type of verbiage?
right. I mean, I don't discourage him from not wanting to go.
Well, you didn't answer my question though. Have you used the word, honey, I want you to see dad?
Not in those exact words, but I do tell him that I want,
A good idea.
right, yes. But I never discourage him from not spending time with his father because every child needs a father and a mother in their life.
So long as they're fit.
Exactly.
Anything else you want me to consider regarding this issue?
I understand what he's saying because he says things to me, exact same things to me.
Have you seen the video?
No.
Want to see it?
Sure.
You have it, sir?
I gotta find it. That was down there.
Okay. And is it short?
I'll have to look and tell you what the time was on it.
I mean, I don't need to see it. I'm accepting your word because you're under oath.
I could get it if it's.
I mean, I don't need to see it. I know because he says the same things to me downstairs before he goes. But this is all new to him. He's 8 years old. He's never had to have parenting time with his father. So this is all new and it's all out of his norm or routine. Our son likes routine. He likes to know step by step of what he is doing.
How long has this parenting time been happening?
Every other week on Wednesday from 6 to 8. And then he just had.
No, but when was this? When did this all start up? Where the parenting time is, because this is new to him.
Right.
When did the new start for you?
Oh, the starting of the parenting time?
Yes.
It was the last time we were in court.
How long ago would that have been? No, okay, so it is rather new. Thank you, Schultz. November.
He's never had to.
I did hear Ms. Dunwoody mention, I'm not sure if he is being evaluated or currently getting services related to an autism diagnosis, but I would highly encourage that both parties follow up with the treating providers, including HBH, because especially with spectrum disorder, routine and structure is very important.
It's
And I would
everything.
highly recommend that they follow up on ways to address that.
Has he been diagnosed or is he in the?
He is in the process right now. I'm waiting for a phone call through Saginaw to set up the autism study or testing. So that hasn't been done yet. He also may be possible being set for a neurologist because the size of his head is somewhat larger than normal. But that's a possibility too.
Is dad involved in any of this?
Not yet.
Why not?
He's on he's on information through his doctor's office. Yes.
Okay, he has joint legal custody, right?
Right.
Okay. I know you've gone your separate ways.
This has all just started, so.
Oh, I get that. But wouldn't this be a good time to basically join forces here on behalf of your son?
Yeah.
Dad, do you agree?
Yes.
I would agree too.
He does also have IEP through the school where he gets extra help in class.
Sir, is your child making comments to you about not wanting to go back to mom?
He has said something about wanting to be around more, but I haven't heard him say he doesn't want to go back to mom. I want to make a good positive note though. I did tell him he's welcome at both places, and that's something I did bring up with friend of the court.
Good, because that's the idea here. Do you see signs that there could be a possible diagnosis here too, sir?
He has, I notice attention problems sometimes.
Okay.
And if you speak clearly to him, it helps out a little bit.
He's hard to understand what he's saying. When he's bored or does not have nothing to do, he kind of panics and says, I don't know what to do. I don't know what to do. What am I supposed to do? What am I supposed to do? And I always have to redirect him. Well, you can do this.
Do you see that, sir?
Once in a while I see it, Your Honor, but reassurance actually helps him out. If you get right in front of him and talk.
And mom's nodding. It's everything you're saying, she's nodding.
Like when I have a conversation with him and he could be sitting in the rocking chair and I would acknowledge him and I'd have to actually go right up in front of him before he says what. I mean, I've had his hearing tested, so his hearing is fine. I had it tested in Carroll at the, I don't know what you want to call that. Not the skills center, but Learning Center. He had his hearing tested there and his hearing is fine. So I'm not sure why I have to repeat myself a couple times in order for him to hear me.
What's your position regarding the support issue?
For
Whether it be 390, 379, 352. Do you have any comment? No, you don't. I just wanted to know.
Not really.
Okay. All right. Is there public assistance involved?
As far as
The family.
he has Medicaid.
Okay.
But
Well,
that's it.
but he's on the insurance, but he's probably on.
He's now on.
He's dual. Okay.
Do I get a medical card from Ryan, an insurance card? So when I do take him to his appointments,
You should.
you're supposed to have both cards. I have his insurance card, but if he has, they'll use his insurance as a primary. Medicaid will be a secondary.
Do you have another card you can provide, sir?
Yes, sir. Can I have the other insurance card too? Yeah, help out.
I only have one. So maybe when he
We'll
goes,
stop at the front of the court office. We want copies for our file, and then we'll give you each respective copies of the other.
There you go. I'll take care of that. Okay. All right. Let's address it in reverse order regarding adult topics. The show cause has been issued. I'm not hearing per se, mom saying, you don't need to go to dad. You don't need to do this. You don't need to do that. This parenting time switch occurred sometime in November, and that is a change. There are concerns relative to the child regarding the child's condition, and whatever Ms. Schultz said to you both, I would be right on top of that. So, Mom, as opposed to the last hearing, it's very important to keep dad up to date and dad being involved as well. Because despite the fact that you're no longer together as a couple, you have a common interest. That's your minor child. And that's number one. So to join forces and unite in that regard would be very important, and to follow through with that. So as it pertains to the show cause at this time, the court does not find sufficient evidence at this point to warrant a show cause relative to mother. As a result, that motion is respectfully denied. Relative to the support issue in this case, the records clearly indicate what they indicate. However, though it doesn't fit the parameters for deviation, the court is going to order support, and is effective December 11th, 352. The court will order support of that amount. Do you wish to use the December 11th date, Ms. Schultz? Is that easier, or should we use another date that works better?
We had originally went back to November 22nd, which was the date of the objection hearing previously. The friend of the court has no issue with anywhere in that range.
Let's make it December 1, please. So the support's lower. It's not to where you want it, but it's based upon the income information. I wish you both the very best. You're both free to go. Thank you. Good luck with your child. 91DS. This is the defendant's motion regarding request for assistance pertaining to the child. Also, support issues, and the court, I believe, has to look at regarding Mr. Barnes' payment plans, employment opportunities, and ability to work.
Does the court wish to start with support or with the constitution?
Let's go with support first.
So on May 30th of 2024, the friend of the court office had issued a child support recommendation. That recommendation was that Mr. Barnes pay support in the amount of $415 per month. Neither party filed written objections within 21 days, and that order did enter on July 26th as recommended. This is Mr. Barnes' motion with regard to the issue of support, and for the calculation that was utilized for the current order, the friend of the court had actually imputed earnings to both parties. Both had reported unemployment at the time of calculation.
All right, so hence if they're receiving unemployment, that means that
if neither was receiving unemployment, but we did use imputed potential earnings for both. Ms. Dieter reported performing some cleaning services, but it wasn't a significant amount of earnings, so we did use the imputation factors and imputed her. For Ms. Dieter, we had used $1,044 per month gross income. For Mr. Barnes, we had used $2,610. And again, we did go through all of the imputation factors that are required under the Michigan Child Support Plan.
Okay. Thank you. Mr. Barnes, what's your objection to the support?
I don't agree with the amount. I have other children that I have to raise at home too.
Okay, well, on to that. Is that considered? Did you consider that in your calculation?
There is credit for one additional biological child. There is not credit for the two stepchildren.
Are these stepchildren?
Yes, I have two stepchildren too.
Okay, that can't be.
And Your Honor, I will differentiate. That calculation is the 2021 Michigan Child Support Formula. The 25 manual does allow certain considerations for stepchildren in the home. That is one of the changes.
That is right. I forgot about that. Two stepchildren?
Yes, I do.
How old are they?
One's 9, the other one's at 9.
And what are you paying out essentially for those other two children?
I'm helping raise them. All of them, well, me and my wife's money goes together, so anything I make, we put in our account and pays together.
So how much extra are you talking per month that you weren't paying before?
Before I got with my wife, probably quite a bit. It's just me and my son, so.
Is there a support order for your spouse regarding her children?
Yes.
It is being paid?
I'm not sure about that. I try to not go into that, so.
But because if it's being paid, that would presume that with support being paid, it wouldn't be so much of a burden upon your spouse.
Right.
But you don't know how much.
I don't know.
Okay. Anything else you wish the court to consider on that issue?
No, I think that'd be it.
Okay. Mr. Response?
Well, I also have stepchildren that live in my home too. I do.
You're supporting them as well?
Yeah, and then my husband and I, we struggle financially as well. It's kind of but I don't see how he's made like 2 payments in 6 months. I went and I got a print off of like the payments that he's made, and they were partial payments even. So
when's the last time you received a full support check?
never.
Never.
Probably like a year
December.
or maybe longer.
There was a full payment December of 23, and there was an additional payment in March of 24. That was an arrears payment.
I think
in excess of the.
Yeah, I think he only really pays like when he gets his taxes back. So I'll get that, they'll take it out, and then I'll get I think in 8 months or maybe even longer, I've gotten 3 payments, and I have it right here.
Okay. Anything else on the support issue? From your perspective?
Currently, Ms. Schultz said, I was working for my church, cleaning and stuff like that. Last year I did get into a car accident and I did hurt my back. Currently I'm in the process of going to rehab for that, or trying to get home with my back issues. So currently right now I'm not even working or cleaning the church.
So there's no disability claim at this point?
No, I'm not gonna go for that. I'm gonna just try to get the rehabilitation I do want to work.
Okay. Next issue, Mr. Barnes, regarding the arrearage. What do you have in mind for payment plans here?
I did.
Regardless of what the amount is.
Okay, I did start a business at the middle of the summer, a painting / deck business. And every time I did get paid from there, I did bring money up. So I know in August, September, and maybe even October, if not, it might be months before, but I know in August and September, I brought in $250 every 2 weeks. I was.
Are you a licensed builder?
No, I'm just a painter.
Painter? Well, don't say just a painter.
No,
painters are very important.
Yeah, the painter. So
okay. Do you do indoor painting?
Yes, I do all kinds of painting. It's just
What's the name of the business?
Byron Services. I have no jobs lined up through the winter. I started it late and nobody's called. So
well, they won't know if they don't know about you.
Oh, they do. It's post all over Facebook.
That's one way of doing it. There are other ways too.
I know.
So you have a business called Barn Services?
Yes, and I think I opened it up in the beginning of the year, not the beginning, the middle of the year, May or June.
Okay. So how are you supporting yourself right now if you're not working?
Not really. Not working.
I mean, you claim you're paying for 2 other children. Where's that money come
from? A little bit of side jobs. I don't know. Just side jobs, really.
What type of side jobs?
Building, working with my wife's uncle, but that ain't every day. That's only like $50 a day, so it's not much.
But clearly shows you're able to work.
Yes.
Good. That's great. What employment opportunities have you sought? It sounds like you have some skills.
Building, to be honest with you. I'm actually been talking to a builder the last couple of weeks to start working with him next week, possibly. So.
What have you said you talked to a builder, but what, other than that, what have you done to seek other employment?
I've went on Indeed and applied places. AutoZone, I've tried doing them guys, but there's a lot of stuff you got to go through to apply.
Every Thursday in the County View, I always review it, and there's always an ad there regarding the local factories.
I can't do factories.
Why not?
Because I don't know. I watched my mom work her life away in a factory and they treat her like crap. That's pretty much probably my reason. So I know it's not a good enough reason. It's not, but I'm also not going to work in a factory. I never have. I've always outside work, farm work.
I know there, at least from what I've seen, there are a lot of people out there, employees, So what can you do in the form of a payment plan?
No, I don't know.
Well, I need something a little more specific than that. The monthly obligations, what is it, 480 or 18?
418, Your Honor, and through the end of January, the arrears on the account are at 4,000.
I need to have something better than that, sir.
Money as soon as I make it. That's the only. I don't know what else.
It's not acceptable. I need a dollar figure.
Probably $200 in the next 2 weeks.
Every 2 weeks, $200?
Yep.
Okay. You want the child in counseling?
Oh, yeah. It's supposed to be. We had that in order a long time.
And you have joint legal custody, correct? Yeah. What efforts have you made to get the child into counseling?
I haven't, because I only have them on the weekends.
Well, you have legal custody, though, joint legal. You have equal decision-making power over the child.
So I could just make an appointment, take him from school and take him back?
Take him back?
To school after the appointment, because I want less, it's always been less contact as always with her. There's always issues.
Well, you have to step back from that. Look, why do you believe the child needs counseling?
The stuff he goes through, when he gets in, say if he gets in a little bit of trouble, he freaks out and cries and can't control himself.
How old's the child?
9.
9. Issues at school?
Yes. People bullying him.
How's he doing education-wise?
From my Skyward thing, pretty decent.
Good. And you said counseling was ordered previously?
Yeah, it's been ordered twice now.
Ms. Schultz?
Well, most recently on January 12th, 24, the court had ordered that he be enrolled in individual counseling services with HBH. I am aware that Ms. Dieter did follow up with Huron Behavioral Health. They did not accept the child for services, and she did provide us documentation for our file.
They explained why.
They had included a reason, I believe the focus at that time was providing their services to those children with more severe behavioral concerns than what they identified in the assessment.
They did a gradation, so if it's not to a certain level, we're not.
Correct. Correct. And she did provide us that documentation that he was taken for an intake assessment.
Okay. How do you respond to that, sir?
I think that he should get some type of therapy.
Who's going to pay for it if it can't be done through HBH? I mean, you're not paying support.
He has Medicaid. I mean,
well, HBH would be the service that would be providing it with the Medicaid.
But is there other therapy though? Therapy people.
I'm not the parent. You're the parent.
Okay, well that's what I'm saying. There's other therapy stuff.
So what have you looked at?
I'll look now since you're giving me the time. I mean, I just didn't. I only get him on the weekend, so I have time to take him during the week, or when it's not my time. I didn't know I could take him when it's not my time.
I'm not saying you can take the child. I'm talking about contacting the agencies to find out whether or not services.
I have none of his medical information. Never had his medical information.
You have the ability to get that because you have joint legal custody.
How do I get that?
I can't. That part
I don't know either.
Can I respond to that?
Yeah, I was going to have you respond.
So after I reached out and had him seen with Huron Behavioral Health, they did deny him being seen there. They said he did not meet criteria. I did let Grant know that I found him services at List Psychological with Deneen Gundon. And he was seen there 4 or 5 different times, which I have the paperwork. And she discharged him. I have it right here. It says discharge outcome successful. Braden has met all his treatment goals and reports. and reports 80% of his symptoms of anxiety gone. He will report a building tool of coping skills to use when having feelings of anxiety. He has built a tool of coping skills to manage his anxiety. And then it says that he will follow up with his primary care doctor if needed, and she discharged him.
How many sessions did the child attend?
About 5. And I did provide Grant with her name and the services provider too, through AppClose.
When did the services end?
This is discharged last date of session 7/18/2024. And also he does seek counseling through his school too, because I've been in contact with the counselor there and let her know that he's been mentioning getting bullied at school. So she has been counseling him there as well.
Who paid for the list services?
I assume Medicaid did.
Okay.
But she also said, Deneen also said that since she didn't see that he was really needing counseling, based on what he was telling her, it would almost be more harmful to kind of like almost like borrowing trouble.
Okay, so obviously new school year, not necessarily new now, but child still being bullied?
From what I've heard from him, no, it's gotten better. It was kind of a situation at recess where they were playing football and the kids like to make fun of each other if they think they're going pro or something, you know, they're going to be in the NFL. And so Braden takes that personally.
So use a child's name.
Yeah, sorry.
So how do you feel about additional counseling?
I'm not super opposed to it.
You're not super what?
I'm not super opposed to it.
Okay.
I'm currently seeking counseling right now myself. So he would be able to actually see my counselor. I actually talked to her about that.
Okay. So want to give it a shot?
Yeah, I can, we can do like family sessions and stuff like that too for.
That work for you, sir?
As long as he's by himself at some point in time, yeah. I want him to be able to actually talk to somebody without someone in there, like, so that way he can open
Sounds like
up.
that's already been done.
Okay, well, I'm just saying, that's all I want.
You have any problem with that?
Nope.
Okay, I'll grant the motion. Relative to counseling, it sounds like List is the place because he's been there previously. The child's been there previously. And
I don't see anyone at List. I go to the what is it called? It's across from Muffler Man.
professional counseling service?
Yes.
Do they accept Medicaid?
As far as I know.
I believe Ms. Peter herself is insured, so it sounds like maybe they are accepting it. I was not aware that they did previously. But I know Ms. Edmonds has brought on additional staff, so they are accepting it now. I'm not sure.
Okay. Well, if it can be done there, that's great. If not, List obviously accepts the insurance.
Right.
And by doing so, we can get this started. It's very important, and I know you don't want to talk to each other.
No.
But you have to. Now, Mr. Barnes, if you are, and I know you care about the child.
Oh, I care a lot about Brittany.
I know that, but that's why you have to take, I can't think of a better term than you sometimes have to take your medicine and just say, look, plug your nose and move forward. You have to, because the therapist is going to want to speak with you regarding the child. Mom will provide information regarding the child, and your input is going to be important. And, you know, if you can't work it at PCS and it's at List, you got to be able to communicate with each other about that. AppClose is ordered, correct? So AppClose will be the function you use. And all you have to think about when you communicate with each other is simply this: what's in the best interest of the child? Just ask yourself, if I send this message, is this in the best interest of the child? In other words, I don't like you because blah, 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 blah. Is that in the best interest of the child? No, obviously not. So you have to be able to communicate. That's the only way it's going to work for a child. So counseling is ordered in this case. Regarding the payment plan is $200 every 2 weeks. When can the first payment be made?
Every 2 weeks.
January 31st will be the first date that it's due. And we will do a show cause in 30 days from there to see how things are going. No, 60 days. 60 days to see how things are going. I will need updated information from you regarding further employment opportunities. Sounds like the construction thing may be a thing that is going to work. I find you're able to work based upon your testimony. Mom's able to work as well based upon her testimony. And that lends itself then to the issue regarding support in this matter. Support was previously ordered in the amount of $418 effective July 26, 2024. Imputed income was provided to both parties. And based upon what I've heard at this point, I see no reason, proper cause, or change in circumstance to differentiate from that. Support amount remains. Good luck to both of you. This is the plaintiff's motion. Strike that. This is plaintiff's objection to a friend of the court recommendation. The plaintiff, Ms. Grates, is present. She's in the courtroom. Mr. Cable, the defendant, is present in the courtroom. Would you both please raise your right hands? Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you. I do. Thank you. As I read the motion, it indicates that mom is requesting more support as the children are getting older and their extracurriculars. Mr. Olber, or is it Mitchell?
Your Honor, the friend of the court had conducted a child support review. The Michigan State guidelines provided that Mr. Capling's support be set in the amount of $393 per month. However, that did not meet the minimum threshold for modification, and the friend of the court therefore recommended that support continue in the amount of $388 per month, effective August 27th.
All right, Ms. Grates, what's the issue regarding support?
I don't think that it's enough. And the reason is our boys are at preteen age right now. We got a 9-year-old and an 11-year-old. Their hygiene needs are different now. We got skincare, we got deodorant now, we got all that kind of stuff. They are both in sports. Our oldest is in basketball and our youngest is in soccer, football, and baseball. So all those, they need athletic gear, shoes, everything that you would need for sports. On top of that, our oldest is an avid reader. When he was in 2nd grade, which was quite a few years ago, he actually hit the mark for 12th grade reading in 2nd grade. So yes, and very, very, very. So what I do, because he is such an avid reader, we go to Barnes & Nobles every month and he is able to get a book. Books now are pretty pricey and it's getting hard to be able to give him the books that he wants because of the money situation. If I did get a little bit more from dad, it would be beneficial. On top of that, he does need a phone. We did talk yesterday about him getting on Sean's plan, and that's acceptable to me as long as he is continuing the payments and making sure that his phone won't get shut off. Our youngest likes to build Legos and robots, so
I walked through a store not too long ago and just accidentally went through the Lego aisle. I couldn't believe the prices. And on top of that, security for those as well. So they're a high commodity, so to speak.
Yes. And right now he's actually building the Death Star Lego from Star Wars.
Why not?
So those are also pricey, along with him building the robots is expensive. And then that's not including the stuff that happened for at school. We had popcorn day. We had Christmas gift exchange. The locker wrapping cost money. Field trips. And then of course school supplies. And because at the beginning of the year, we always have the seasons, right? So when we are talking about clothing, we have school, we have the supplies, and then we have winter coming up, coats, snow pants, boots, all that kind of stuff. And then we have summer, which is we all need summer clothes and summer shoes. So all those things cost money, and I'm just asking that he pay a little bit more.
How much more are you asking for?
I would like $60 a week per child. We have 2 boys. all this stuff costs quite a bit of money.
120 per week.
Yeah. And the last 6 months, the total for December was $84. The total for November was $35. I didn't get anything, zero in October, and $84 in September, $50 in August, and $79.90 in July.
So you're asking for, I used 4.3, Michelle. I thought it was 4.35. I just put 4.3. So you're asking for an additional $516 per month.
He is only
I didn't use 3.5. I used 3.
he is only paying what is $42 a week per kid.
What is the current support obligation, Michelle?
$388.
There it is, 388. Yep. Okay. Has anything changed in your income or his income?
I don't think so. I mean, I don't know on his end. On my end, I do own a cleaning business, and right now, I don't have any clients until March.
Okay. Okay. Let me hear from Mr. Cable on this. Sir, your response.
My response?
Yes, to all this.
Yes.
Yes, what?
I agree with what she said.
You're willing to pay more support?
I'm willing, yeah. I'm currently unemployed right now. I'm hoping to get back into work in this next season coming up here. Seasonal landscaper.
Okay. So you're currently paying 388. What are you proposing you can pay? Per month. If it's 388 now, essentially she's asking for over $500 additional a month.
I don't need that much, but I mean, $42 per child a week really isn't doing much, and especially within the last
But
6
understand
months.
that's pursuant to the guidelines. I mean, that's a calculation the state of Michigan requires us.
That's not helping my boys though.
I get that. I get that. But I have to follow the law. So it's 388 now. You have a proposal regarding a higher amount?
Because that's
Sure.
what we would be able to pay.
Yeah.
I'm not sure exactly. They always just took it out of the paycheck, so.
Right.
And
What about this? I'm just going to throw numbers at you. It's currently 388. 500
500 a month
per month.
Sure.
600 a month. Now, don't go to a level that you're going to cause an issue here. I'm just trying to get an idea here. Because if we have to have support enforcement orders and you're held in contempt for failing to pay child support, that's not a place you want to go.
Yeah. I don't know. It's hard for me to remember exactly with being off of work for so long.
Well, how are you supporting yourself right now?
I'm getting help from my father.
Is there an arrearage?
Yes, Your Honor. As of the January 31st, the arrears on the account are $1,948.23. Mr. Capling historically is very good about paying when there's an active income withholding. However, our last full payment is received as of April of 2024.
So he was working this past summer.
He has always had a seasonal variation, and that is taken into account in the Michigan Child Support Calculation.
Well, maybe I jumped the gun here because if there's an arrearage, you can't even pay what you're ordered to pay right now. Right?
I don't know what that means.
Well, what that means is you have an arrearage of $1,948. That's back support.
Okay, yeah.
That's due and owing that you've not paid yet. If I up the support amount and you already have an arrearage, I can't see how you can even be successful in doing that. So you need to really think hard about this, about what you can pay. Because I'm going to tell you right now, at the bare minimum, it's 388. And when do you anticipate getting back to work? April?
Hopefully, yes.
Have you sought other employment for other jobs?
Not yet, no.
Why not?
Um,
Certainly help your dad.
Huh?
It would certainly help your dad.
yes,
Supporting
it
you.
would. I like my old job that I had, and I'd rather not go back to a factory or.
Well, I'm not saying a factory. I just know that there are advertisements for that, but I know there are other jobs available.
Yes, Heather, I apologize. I was on the wrong line of my screen. The arrears through January 31st is actually $2,798.
So we're approaching $3,000.
Yes.
Unpaid support.
May I make a suggestion for the parties, Your Honor?
Please.
I would suggest, Michigan Child Support Formula indicates that support is in the correct amount at this time. If you wish to do an upward deviation, perhaps that's something that you want to allow Mr. Capling to return to work and then set up an appointment to come in and meet with the friend of the court. We can facilitate the order based on the agreement that you have. But that would be my suggestion.
What are your thoughts about that?
That sounds really good.
Sir, what do you think?
Sounds good.
Thank you, Ms. Schultz. I agree with that. And the court will order that. In the meantime, support remains at $388. If you can pay more, obviously go to the arrearage first. We want to take care of that arrearage. If you don't take care of the arrearage and it's brought to the attention of the Attorney General's office, it gets to a certain level. I don't think you're at that level yet, but it doesn't take long to get there.
Yeah, I was gonna ask if,
You can be talking about a felony charge.
yeah, where it starts turning into all that.
Yes, you don't want that.
I've been a little worried about that, being off work for so long.
That threshold is $10,000. However, currently based on the arrears, there is already a task force suspension. Back out that will happen.
Yep.
The enforcement has already begun outside of our local office and stop those processes as the Office of Child Support.
Right. And intercept.
Intercept will happen.
Yep.
Task order is suspended.
Okay. All right, support remains at $388. The recommendation or the objection of the friend of the court, the objection of the FOC recommendation is respectfully denied based upon the current circumstances of the parties. However, I've ordered that when the employment changes and if there's an upward departure, either party contact the front of the court to set up that appointment to address that. And if the folks are getting a little too crazy, Ms. Graves, all I can suggest is we have one heck of a library system in this county.
Do you use the library? Very, yeah. Oh, yeah.
Good for you, because we have a heck of a library system and across the county, they can snag books.
We use Mel every day. So
Excellent.
it's just a reward for him, because he loves reading. We have a little library going on in his room. And it's just something to keep him motivated.
I knew a cabling from years ago that loved to read too. Peter B. All right. Good luck to both.
Thank you.
That'll be all. Has been scheduled today. And Mr. Emmerich is present. For the record, plaintiff's name is Norma Moreno. Holdick prepared the show cause on November 5th. And Mr. Holdick, do you want to shed some light on this, please?
Yes, Your Honor. This is a spousal support only matter, which is why I set before the court. Last year in November, the court has reserved the show cause for Mr. Emmerich based off of his testimony to meet with myself to try to set up a payment plan, and then further set the show cause down the line to monitor for compliance with said payment plan. He did stick around after the last hearing in November and met with myself. We did discuss his case, his financials, and currently what's going on with his life given making payments. He had agreed at that time that he would try to make a minimum of $200 a month, roughly $50 a week, and would make efforts to try to pay in excess of that. After that meeting was conducted and Mr. Emmerich had left, we had set this for review hearing for today, gave him a number of months to complete payments. I do see when I look at my payments that in November, $350 was paid. December, there was $100. And then showing for January, it appears a number of payments actually posted just yesterday for today's hearing online. Mr. Emmerich has been trying to do the expert pay online. I believe auto pay was having some difficulty. I'm assuming it may have went through because now I see $250 that were made for this month so far. And they do show in the system as weekly $50 payments that just posted it all at once.
Okay, so we're behind in November, $150. We're behind in December, $400.
The agreement that he was able to do at the time was
Oh, $200.
$200 a month.
I'm sorry.
Correct. So
Okay,
for November, he paid in excess of $150. December was a light month, only $100, and then so far this month, he's paid $50 over that agreement.
Okay. We are seeing compliance. It's just.
Correct. And it's charging $800 a month, and at this point, there's an arrears of $2,750. So like I said, they're showing a compliance with that $50 a week payment plan, 5 months in. So as stated, this was just a hearing just to see, monitor for the compliance.
What we're doing. Right, let's just see how we're doing.
See how we're doing, correct.
Okay. Mr. Emmerich, what say you about this, sir? I didn't place you under oath. Would you please raise your right hand? Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but so help me God? Yes. Sir, your name is Randy Emmerich. Mr. Emmerich, what would you like to report to the court regarding the status of these payments?
Okay. I tried to get through expert pay. And nothing. I mean, it is hard to get anything. The last time I was on the phone with them, I couldn't get my checking account or banking account information in there. So I called, get a guy on there. And I said, listen, it won't take, because it keeps saying it's in there because I put all the information in there. But it doesn't show up there. I can click onto that to get recurring payments. So he said, well, all I can do is clear that out. So I said, clear that out. I'll go back into it and get it. And he cleared the whole thing up. So then I had to go back and redo it all. But now I got it on, I go through PayPal. Now it will go, I got that all through my checking account. So $50 a week will be pulled out to go to PayPal to go to expert pay. And let me tell you, it is a chore to get any help on that expert pay. It is a chore, and I would go on it, and I will be honest with you, my phone might have been tossed a little bit because you can't get no support at all. There is none. Yes.
Well, isn't there an option of paying directly to the front of the store?
My understanding is Mr. Emmer is a truck driver, so he's not in the area.
Oh, okay.
However, if I heard him saying that he now has the auto pay set up, but there is an option where you can request billing funds from the state disbursement unit, and you can send out a check, a personal check. We can't take within our local offices. And I'm wondering if maybe that would just be the easier option.
Well, it's all set up. We're not going to go backwards on that one. So hopefully from
Are you saying you're golden then?
I'm hoping it works. I'm because let me tell you, I put a lot of hours on the phone listening to the silliest music you could ever hear and trying to stay patient, you know. So now that we went through PayPal, it shows that it's once a week till whenever we say no.
Mr. Holwick, is it showing that there were payments made now?
Yeah, yeah. So when I had checked the system before court yesterday, it did not show any payments for January. But this morning I look at it and I have a $50 payment that was on January 7th, a $50 payment on January 8th, and three $50 payments on January 9th. So however he had it set up, it did go through and get processed, and it did.
Hallelujah.
Thank you. Thank you very much. That's what I said yesterday, because I think we just got it yesterday or the day before yesterday, set it up because I didn't want to go I didn't realize that PayPal will still go to export pay or whatever, expert pay. Yeah.
Okay. Well,
so then yesterday we just said, okay, or maybe it was Wednesday. We said, let's just try PayPal. As long as it goes to where it needs to go, I don't care,
okay.
You know, so as long as it's going.
Ms. Schultz made a good suggestion. If that doesn't work along the lines of the check and getting the coupons from the disbursement unit, but at the end of the day, I find that you are in compliance, but doesn't address the arrearage. The arrearage is still growing. So I'm going to do a review in 90 days to see how things are progressing. And the review at that point, I will, because you are an OTR, over the road truck driver, you can appear via Zoom.
Okay.
So don't toss your phone.
Your Honor, can I make a suggestion on that? For the 90 days out, getting closer to that Friday, if Mr. Emmerich can contact us maybe a couple of days before that hearing, if payments are compliant, if it's okay with the court, front of the court can either set aside that show cause or adjourn for monitor, continue to monitor compliance, just so Mr. Emmerich's not having to take time off of work.
So you're giving him additional grace then.
He's compliant, so.
Yeah, that's the point.
Why not? Mr. Emmerich's been compliant with
See?
our office, in the past, so.
I appreciate that. I think that's a great suggestion. In other words, if you're making your payments, we'll schedule the 90 days out. Give Mr. Holdwick a call before the 90 days are up. Mr. Holdwick may say, you know what? You're in compliance. Maybe we need to tweak this or tweak that or keep it going. And then you won't have to take time off of work to be here.
Great.
That's what we'll do. Good suggestion, Mr. Holdwick. Appreciate it. So we'll do a review in 90 days. I won't have a date here at this point, but just continue to watch your mail. Stay in contact with a friend of the court. And hopefully I won't be seeing you for a while in this setting. Any questions, sir?
Now, I got a question about if maybe we can't answer it at this one right here, but there was a lawnmower that was involved with this whole thing.
In the divorce proceeding?
Yes.
You need to file a motion.
Okay,
You have to
okay.
file a motion. Is there anything else from the front of the court that we did not cover? All right. Thank you. Good job.
Thank you. Thank you.
That'll be all. Thank you.
Thank you very much.